Carmela.
Okay, so good morning, everyone. So I can see that everybody is here. We are currently 440 here. Ayan. So a virtual clap, everyone. Ayan. I hope you are hearing me loud and clear. So before we start, let me introduce myself. My name is Miss Carmela Tongsan. I am the Marketing and Admissions Officer of Olivares College Tagaytay. So we welcome you to our today's event, which is the Advancing Knowledge in Copyright, Fair Use, and Intellectual Property. Um, of course, initiated by Olivares College Tagaytay, our learning resource department with the partnership with Regalo Touching Lives. Ayan, maraming salamat po for joining us today. So, I see dito po sa ating chat box. Sige nga, babati ako ng konti. Um, Medyo marami. Wait lang po ha. Ayan, so meron nag-good morning from Capiz. Hello po sa inyong lahat. And also from Bulacan State University. Hello, good morning. As well as, wow, from General Santos City. Medyo malayo pala ang nararating natin. Good morning po sa inyo dyan. Agusan del Sur, DLSU Libraries Manila, hello. And Tagbilaran City, hello. Meron pang Cotabato City, General Santos Doctors Medical School Foundation Incorporated. Ayan, Bohol. I don't know how to read this, pero basta po taga Bohol. Okay, and then Cebu. And of course, from Olivares College Tagaytay and Olivares College, our main campus in Parañaque City. QCPL, PCC Caloocan Campus. Ayan, sobrang dami niyo po. And Legazpi City, Palawan. Yan po nakikita ko. So once again, good morning and welcome to our today's seminar, which is entitled Advancing Knowledge in Copyright, Fair Use, and Intellectual Property. So I think this day would be very exciting as we will be learning a lot from our resource speaker for today. So ano po, samantalahin po natin ang pagkakataong ito to learn something. Ayan. So this is actually our chance to learn a lot of things. Okay? So sige po, we'll start the program. Ayan. So may I invite everyone, ayan, reminders lang po, kindly turn off your microphones para po hindi tayo maawala. Okay, so may I invite everyone for the invocation and the singing of the Philippine National Anthem and the Olivarian Hymn.
Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang magiliw, elas ng sinakalan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, tuyag ka ng magiting, sa manlulupin, di ka pasisigil, sa nagatang tutok sa simoy at sa langit ang pagaw, ay hinatang tulad, awit sa pagkayang minamahal, ang isang ng matawad mo'y tagumpay na naghihinig, ang bituin at parang niya kailan, ang may di magtitingin, luman ang araw ng warhabit pagsingka, buhay langit sa piling mo. Ang ligaya na pagkay mga aking, ang mamatay ng dahil sa'yo.
Our Heavenly Father, the fount of all goodness and grace, the cause of wisdom, the source of intelligence, we welcome you, O Lord, to this auspicious gathering of your beloved, who continuously give you thanks for every opportunity to learn something new and become fruitful to the works of your creation. We humbly come to you, not because we are worthy, but because we find ourselves in need of you, who is our strength and our hope, to continue despite the challenges we face in health, prosperity, and our solidarity with one another. We pray that today's gathering, made possible by the grace of advancements in technology and social media, becomes successful in its endeavors, so we can offer it back to you as our humble offering to honor you, glorify you, and love you through our deeper connection with everyone. May we find bliss in today's session and become more productive children and co-creators of the earth. This we ask and pray through Christ our Lord. Amen.
Okay, so thank you so much everyone. Ayan, as I have noticed, sobrang dumadami na ating participants. Na medyo mabilis ang pasok ng ating participants. So anyway, good morning once again. My name is Miss Carmela Thompson, so I will be your host for today. So welcome to our today's webinar, which is Advancing Knowledge in Copyright, Fair Use and Intellectual Property. So let me just state the objectives of the program. So after the training or the program, students and faculty will be able to, number one, understand on how to apply the copyright law, principles of fair use and intellectual property, and instructor and learner usage. Number two, differentiate what is copyrightable and what is not, copyright infringement and plagiarism. Learn how to protect themselves with the proper use of learning resources and respect and the works of others. And of course, raising awareness of the intellectual property. And lastly, become a responsible digital citizen. So without further ado, let me call from our Human Resource Department, Miss Carla Erica Serran, to give her welcome remarks.
Um, First, hi, good morning. First, I would like to greet everyone a good and healthy morning. So, it's a great pleasure to be here today to open the seminar. I am glad to our dear committees for make this program possible and to our visitor and also to our guest speaker will be with us this morning, sharing his expertise about advancing knowledge in the copyright, fair use, and intellectual property. I know and we all know that since the COVID-19 pandemic came, everything was not easy for everyone. From the different challenge and we experience and the new normal to the after effect of this adjustment, I hope this program will contribute a big help for us. Wishing everyone a clear mind, we clear something to support a new daily normal living. Once again, good morning and be safe everyone. Thank you.
Thank you, Miss Carla, for the warm welcome remarks. Okay, so let me proceed to the next part of the program, which is the introduction of the speaker. May I invite the head librarian of Olivares College, Tagaytay, Miss Arline M. De La Cruz.
To our beloved Dean, to all academic heads, faculty, and students of Olivares College, and to all our visitors, good morning. Thank you for being here with us this morning. Today, it's my pleasure to introduce to you a very special guest speaker from the Department of Intellectual Property Office of the Philippines. He is the incumbent and the first director of the Bureau of Copyright and other related rights of intellectual property of the Philippines. He began his service in the IPO bill in November 2018. He managed the Bureau's three divisions, namely Accreditation and Standard Division, tasked to hear, decide, and recommend resolution in cases falling within the Bureau's original jurisdiction, as well as the Accreditation of Collective Management Organization, Creative Sector Development Division, which takes charge of developmental programs and projects for copyright-based industries, and Copyright Services Division, tasked to accept and process copyright registration and to undertake studies, survey, and researches on copyright and other related rights. Today, he will be sharing with us his expertise in the topic Advancing Knowledge in Copyright, Fair Use, and Intellectual Property. With that, I ask you to give your full attention to Attorney Emerson G. Puyo.
Good morning, everyone. Thank you, Miss Arline, for the introduction. I hope you're hearing me well. So magandang umaga po sa inyong lahat. I think I'm going to use a mixed Taglish for today. So that we can explain better the concepts in copyright, fair use, and intellectual property. Just as a disclaimer, I will be touching more on copyright and fair use and just a bit on intellectual property. So let me first introduce my office. We are the Intellectual Property Office of the Philippines. I am from the Intellectual Property Office of the Philippines, and we are the lead agency of government mandated to implement state policies on intellectual property. Uh, and this is by virtue of Republic Act number 8293, otherwise known as the Intellectual Property Code of the Philippines. What is this thing about intellectual property? Well, the basis in the fundamental law, which is our constitution, it states in section 13, article 14, that it is the objective of the state to protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such period of time as may be provided by law. So therefore, there is some sort of a balancing that needs to be done in terms of intellectual property, because on one hand, it is the exclusive right of scientists, inventors, and artists and other gifted citizens. But on the other hand, intellectual property also bears a social function. So, us in the Intellectual Property of the Philippines, Office of the Philippines, or IPOPhil, uh, it's our objective, it's our desire to always balance between public good or public benefit and the exclusivity granted by our intellectual property regime to Filipinos or to artists and scientists. So, of course, that particular provision of the law or of the Constitution is not self executing, and therefore there needs to be a governing law. And the governing law in this particular case is Republic Act number 8293, otherwise known as the Intellectual Property Code of the Philippines, which became effective January 1, 1998. So it's been more than 24 years since the passing into law. There were subsequent amendments, not specifically, some of these are not specific to the IP code, uh, meaning not directly to the IP code, but other laws which impacts on certain provisions of the IP code. I'm talking about Republic Act 9150 on protection of layout designs of integrated circuits. And then you have 9502, which is the Cheaper Medicines Act or Bill. And then you have RA 10372. This one is a specific amendment of the IP code. In particular, it created the Bureau of Copyright and other related rights, which I now head. So let's go now to the topic of what is intellectual property. According to the World Intellectual Property Organization, intellectual property is any product of the human mind. Any product of the human mind. That's why the rough translation of intellectual property in Filipino uh, is yamang isip, no? Intellectual property, it's a property, yes. It's any product of the human mind, and it's indeed something that is to be considered as an asset. So, intellectual property or yamang isip is any product of the human mind. So, we have two broad categories or sets of IP rights. On one hand, you have industrial property rights. So I'll go to them one by one. Ito na yung portion natin on intellectual property. And on a greater detail, I will be discussing copyright and related rights. So yan yung two broad categories of intellectual property rights. So let's go first to industrial property rights. Sa industrial property right, you have first and foremost trademark. Saan nag-a-apply ang trademark? Trademark protection is available for any visible mark, okay, which identifies the source of good or services from that of another. So, trademark, ito yung logos, visible marks nga ang tawag, that aims to identify the particular source of a particular good or service that you are availing of as a consumer or user of a product or of a service. So, trademark, applicable yan sa logos, okay, or any signs that distinguishes or parang ito yung name identifier of your business. Okay. Then you have patent. Okay. Patent is available, is the protection available for your inventions. Uh, Patent is for inventions. There are three criteria to establish patentability of a product. It must be new, industrially applicable, and involve an inventive step. Pero that's, we need, you may need another session to discuss all of this. So, pahapyaw lang yung gagawin ko ngayon. And then, you have utility models. In other jurisdictions, they call this the petty patent. Hindi siya, it's almost similar to an invention, but a utility model, in short, is just a utility model is just an innovation of an existing invention, okay, of an existing system or process. Patent, on the other hand, requires novelty. Dapat new. Dapat walang nauna, walang katulad sa mundo for it to be granted patentability. Whereas in utility model, meron na, but it's an innovation of that existing invention. So utility model, when you think of utility model, the short word for you to remember is innovation. Industrial design, okay, is the protection naman for lines, colors, etc., which is applicable for the aesthetics part. Okay, so when we talk of aesthetics, industrial design, utility model, okay, utility model is innovation, patent is invention, trademark is your visible mark. Then you have geographical indication. Geographical indication is an intellectual property system that protects yung origin of a product that owes its uniqueness, kumbaga, doon sa geographic location where the product is from. It may be because of the topography, the geography, the climate in that particular area that gives that product uh, its uniqueness. So geographical indication ang tawag po dyan. Layout design of integrated circuit is self-explanatory. This is for your electronics parts. And undisclosed information is sometimes called trade secrets. Undisclosed information is trade secrets. Alam ko, in the past, di ba, yung 7 herbs and spices, undisclosed information yan. When we talk of trade secrets, the owner of the trade secret must have exerted efforts and means to protect his trade secret. Okay, so there is no need for disclosure, unlike the other industrial property rights, trademark, patent, utility model, industrial design, GI, and layout design. So the second broad category of intellectual property rights ay tinatawag natin na copyright and related rights. Sometimes I will refer to copyright and related rights as the mother of all rights. Why the mother of all rights? Because copyright or the creative expression is the start actually of your applications for trademark, patent, utility model. For patent or invention, one thing that you need to have in terms of uh, processing an application for patent would be a research. So the research material is in fact protected, also protected by copyright. When you have a trademark and you wanted to have a logo, that logo is first protected or protectable also as a artistic work. when you have drawings, when you have illustrations, or even when you have pictures, which you use as your logo or trademark, then that's also first and foremost protected by copyright and related rights. So, having said that, I will now proceed to our main topic, which is copyright. So, what is copyright? I know many of you are into the information and library services sector. So, alam ko, familiar na kayo dito sa concept of copyright. According to WIPO, in this particular publication, copyright is the legal protection extended to the owner of the rights in an original work that he has created. So, legal protection, there must be an owner of the copyright. There are certain rights that goes with copyright, and the copyright extends or protects original works that he has created. But as you will later on note, that copyright protects not just original works, literary, artistic, and scientific works, but also derivative works. So the concept of derivative works, I will touch on later on. So what works are protected by copyright and what are not protected? Meron bang works that are protected by copyright or protectable by copyright, and what are not protected, if any? So works protected by copyright are uh, categorized into two broad categories. One is original works, original literary, artistic, and scientific works. And the other main or broad category of works protected by copyright are derivative works. Uh, Magkaiba ba yan? Not necessarily, but just the character ang magkaiba. Kasi kung derivative work siya, example of a derivative work, a film adaptation of a particular story. Example, Harry Potter. Harry Potter has been made into a film, it has been adapted into a film. The film is what you call as the derivative work. The original work is the novel by J.K. Rowling. And therefore, meron silang magkahiwalay na protection. But note also that under original works, meron din dyan film. Film is an original work created by copyright. But it's because it's not an original work, it's a derivative of something else. And therefore, for purposes of copyright law, it's classified as a derivative work. But make no mistake, the derivative work should also come in the form of a literary, artistic, or scientific work. So you have original works and you have derivative works. So original literary and artistic works, I put here the particular section so that on your own you can study the intellectual property code, the copyright law. If you wanted to learn more about copyright, I always say even to my staff that the easiest way of studying this is to go to the provisions of the law. Okay? Part 4 of the Intellectual Property Code. In particular, you will find reference to original literary and artistic work, artistic and scientific works in section 172.1. So broadly, these are classified into literary works. So you have books, you have pamphlets, other articles and writings, you have magazines, you have newspapers, you have letters also protected by copyright as a literary work. Then you have the works of the performing arts, and these are includes dramatical musical compositions. Ito yung operas nyo na tinatawag, ito yung musicals nyo na tinatawag, or even dance, your choreographic works, or entertainment in dumb shows or pantomimes. We call this pantomime. So these are performing works of the performing arts. And under works of the performing arts included yan yung musical compositions with or without words. So pwedeng instrumental yung musical composition or this is accompanied by lyrics, which is now also classified as work of the performing arts. So literary works, you have four major categories there, four classifications there, from books to magazines to lectures or sermons and to letters. And then you have works of the performing arts. This includes, yun nga sabi ko, your dramatic and dramatical musical compositions. And you have your choreographic compositions as well as your musical compositions. Why are they called works of the performing arts? Because these are works that are intended to be performed before an audience or before the public. And you have now works of the visual arts. The works of the visual arts would basically be your letter G, H, I, and J of the particular section I am now referring to. And this talks about architecture, sculpture, engraving, designs for articles of manufacture, illustrations, maps, plans, etc., as well as drawings. So these are works of the visual and applied arts. And then you have audiovisual works or motion picture. Kadalasan ang alam natin na tawag dito ay film or your cinematographic work. That falls under audiovisual works or motion picture. And lastly, you have computer programs as a protectable subject matter by copyright. I hope you are still listening to me. I think I have a weak connection, so time and again, my video connection is being cut off, but I hope not my audio connection. Okay, so derivative works naman, on the other hand, is also protected. So this includes dramatizations, translations. So if you translate a particular book from one language to another, that's called translation. Let me just quickly point out, however, that translation is not the same as transliteration. So what is protected as copyright, as a derivative work under copyright, is translation, not transliteration. Okay, dramatization, adaptation, abridgments, arrangements such as arrangement of a music composition. The arrangement is entitled to a separate protection as a derivative work, and other alterations or uh, uh, transformation of literary or artistic works. So you have dramatizations and you have collections of literary, scholarly, or artistic works, and compilations of data and other materials which should be original by reason of the selection or coordination or arrangement of their contents. So you have collections, dramatizations. So you have the transformed work entitled to a separate copyright protection as a derivative work, and the collection of literary, scholarly, or artistic works is protected as a separate derivative work if it is original by reason of the selection or coordination or arrangement of their contents. So I know many of you may also be of the younger age. So ang example nito would be your playlist. The playlist, which is your personal favorites, for example, of music, okay? That playlist as a collection, because it's original by reason of the selection, okay? then it becomes a separate copyrightable work from that of the original work for each of the music. Or let's take, for example, a collection of essays. There is copyright protection in the individual essays, but the collection is also protected as a separate derivative work, as a separate work, as a derivative work, because it is original by reason of the selection. So, meron kang tinatawag nyo yata sa mga bata pa dyan, tinatawag nyo itong filter. There is some kind of a filter. There is an originality that you put into it. There is a criteria that you put into it. There is a creative effort that you put into it so that it becomes original by reason of the selection. Hindi lang basta kinolate mo, you did not just collate and collect it and then put it together, then it's derivative work. No, it must be original still by reason of the selection or coordination or arrangement of their contents. So that's it for what works are protectable by copyright. You have original literary and artistic works, artistic and scientific works, and you have derivative works, which could include dramatizations and your compilations or collections of scholarly, literary, and artistic works. So, merong mga bagay-bagay that we have learned that are protected by copyright, but there are also works that are not protected by copyright. And these unprotected subject matter are contained in section 175 of the IP code. Again, all the references I made is for you to be able to study this on your own if you wanted to gain and expand further your knowledge on the topic of copyright. So, unprotected subject matter includes idea, a concept, or a principle. So, ideas are not protected, concepts and principles are not protected. So, your mathematical formulas, for example, are not protected. Your scientific theories are not protected, are unprotected subject matter under copyright. But there is a different regime that will protect it, and I will talk about it later on in the presentation. So, idea, concept, and principles are not protected. Procedure, systems, and methods of operations are also not protected. Discovery or mere data, mere information is not protected. News items or items of press information are also not protected by copyright. Official texts and translations of laws are not protected. So yung IP code, for example, or decisions of the Supreme Court for lawyers, or laws or ordinances from your local governments, these are not protected by copyright, including the translations of those particular laws. So from English, meron siyang Bisaya version or Bicol version, then these are still not protected by copyright. And lastly, works of the government are not protected by copyright. So dito natin makikita, by having an enumeration of unprotected subject matter, this is where we see the balancing of rights principle. That on the other hand, we want to grant exclusive rights to creators, but on the other hand, on one hand, we want to grant that exclusive right, but on the other hand, we also want to have these works enjoyed or used by the public. So that's the balancing of rights principle by providing for unprotected subject matter. Okay. Here you have, I said earlier that if you note that ideas, concepts, and principles are not protected, This is because of the idea expression dichotomy, uh, which provides that only the expression of an idea is protected by copyright, not the idea itself. So it's the particular expression of an idea that is protected by copyright, not the idea of not the idea itself. So let's take a particular example, a classic example, the idea, the concept of a poor boy falling in love with a rich girl. Okay? Mayaman mahirap. That's an idea. A love story between a poor boy and a rich girl is a classic idea, but that idea is not protected. So how do you now protect that idea? You have to have a specific expression of that idea, so that expression can be in the form of a story, a book, a fiction book, or it can be in the form of a film. So that film in the book, it being an expression of a general idea, of an idea, is protected by copyright. But the idea itself is not protected by copyright. So others can have a similar plot, a similar story, a similar idea or concept of a rich boy falling in love, but the specific expression will have to be different. Otherwise, kung kokopyahin lang niya sa iba, yung expression, even the expression of that idea, then it is tantamount to a copyright infringement. So how do I acquire copyright? Meron bang proseso na kailangang daanan para magkaroon ako ng copyright so that I will be entitled to the copyright in the work that I do? We have the second principle, which is automatic protection. Works are protected by the sole fact of their creation. The moment they are created, then copyright vests in you. The moment natapos ko yung libro, natapos ko yung essay ko, then I already have copyright in the work, irrespective of the mode or form of expression, as well as their content, quality, and purpose. As well as their content, quality, and purpose. So even if by standards, by artistic standards, I made a watercolor painting or a watercolor work, and by artistic standards, hindi siya pwedeng i-classify as quote-unquote fine art because it is so basic, yung nothing special about it. Still, regardless of the quality, I enjoy protection in that particular work of mine, it being an original work. So, how do you now acquire? So, sabi natin, automatically protected. However, you must comply with the requirement of originality. So, there must be originality in your work. Kasi kung ang pag-uusapan ay ginawa mo yung work but all you did is to copy it from somebody else. Example, di ba uso dati when we were younger, uso yung tracing pad. So there's a particular drawing of something, maybe of an animal or of a fruit or of anything, then tinitrace natin yon, di ba? You exert effort to trace it and then you now have a work. Is that protected, your work protected by copyright? No, because there is no originality. You just traced it and copied it from something else. So there must be the requirement, although automatic yung protection, but the work must be original. There must be originality. And the first requirement under originality is that it is an independent creation. In other words, you did not copy it from something else. You did not lift it from something else. Okay? You did not borrow it from something else. So it's your creative input. It's an independent creation. So that's the first requirement when we talk of originality. It must be an independent creation. So for example, I'll go quickly through this. some time ago, this is around 2017, there's an issue about whether or not a particular work, sculpture work in the University of the Philippines is plagiarized or is copied from something else. So what you see here, the golden lady na parang nakasuspend siya on air, is the one is the sculpture available in UP in UP, and the question is whether this is plagiarized. So here you have Uplift by Ferdinand Cacnio in 2017. It's available in the UP campus in Diliman. And pero meron kasi siya, merong halos parehas na Virgins of Appledorn, which is a sculptural work of almost a similar character that is in Netherlands. So 2001, yung isa 2017. So does this meet the originality criteria? It really depends on the circumstances. If I were to defend Mr. Cacnio, I would argue that originality does not require that it is new or novel, na wala siyang katulad sa mundo. Originality only requires that it is an independent creation, that I did not copy it from something else. So what you need to prove, kung sana nagtuloy-tuloy ito, kung nagtuloy-tuloy yung case, kung nagkaroon ng case out of this, but I think it was settled among themselves. Kung nagtuloy-tuloy ito, then the argument could be that Mr. Cacnio did not have a specific knowledge of, hindi niya nakita, he was not aware of the Virgins of Appledorn as a sculptural work in Netherlands. And therefore, masasatisfy mo pa rin yung independent creation criteria of originality. It's important that you do not have any knowledge, you did have not come across. But as I said, sa makapagong panahon ngayon, where you have the prevalence of social media, you have the prevalence of the internet, lahat ng bagay kinoconsult natin si Mr. Google, I think it is really becomes more and more excuse na you are not aware, because there is nga the sharing of information, worldwide sharing of information available on the World Wide Web or on the internet. So originality, it must be an independent creation, and there is a certain creativity involved in the process. So there is a creative input from the creator or from the artist. So there is a certain creativity involved, and we're not talking here about sweat, yung effort or time that you dedicated in it. We are talking here about the creative aspect that you put into the work. So originality requires it's an independent creation, and that there is a creative input from the creator or author. And this is emphasized and highlighted in the example of yellow pages and white pages. I know the younger generation can no longer relate. Dati, if you're a subscriber of a certain telecommunications company, then meron siyang white pages or yellow pages as you call them. Here, in this particular case, ang naging issue is whether or not, dahil kinopya siya ng isang, yung directory, yellow pages is actually just a directory of telephone numbers and the owner of those telephone numbers. So if you wanted to locate somebody, then you just go to the directory, and then you look for the number, so now you can call them. But sabi dito, there is nothing remotely creative about arranging names alphabetically, because it's just a collection. You just gather the names and telephone numbers, you arrange them from A to Z, which is the English alphabet. uh, according to their surnames. So arranging names alphabetically in a white pages directory is there is nothing remotely creative about it. It is an age-old practice according to this particular case, which is a US case, firmly rooted in tradition and is so commonplace that it has come to be expected as a matter of course. So there's nothing remotely creative about it, and therefore, that work, even if you exerted so much time and effort in collecting the data and in arranging them according to their surname, there is nothing remotely creative of it. In terms of originality, you will not meet the creative input criteria, and therefore, the work is not protected by copyright. The work will not be protected by copyright. So, somebody copying or uh, making a similar directory is not an infringement of your right because there is no copyright to speak of in the first place. So, there are workarounds based on this principle. So, you can arrange them, for example, by industry. So now you do not just have an alphabetical listing, but you have arranged them. You have applied a certain degree of creativity, very minimal ang requirement for creativity, so that it's now protected by copyright. So, originality, copyrightable dapat yung subject matter, and I already discussed what are the copyrightable subject matter. Ito yung original literary, artistic, and scientific works. So ano naman ngayon? What does it mean to have copyright in a work? If you have copyright in a work, you are afforded or granted by law certain economic rights and moral rights. Economic rights are exclusive rights that allows the creator or the artist to make money out of his work, to achieve compensation out of his work. And moral rights are intricately connected to the personality of the creator. Ito yung personal connection ng creator to the work. So let's now go to these things. Economic rights, you have 7. So kung ikaw ang copyright owner, okay, reproduction, only you. It's called exclusive right. It's called exclusive right because nobody else can exercise these rights aside from you, except when you have granted permission to another person or to another party. So, right of reproduction. Let's say I'm the writer of a book, only I have the right to reproduce a book or an essay or an article, for example, because I own the copyright, and copyright includes economic rights. So reproduction is one of those economic rights. So only I have the right. So let's say, for example, a magazine wants to publish it. So I now have to give permission or authorization to that particular party or person in order to reproduce the work. So the right of reproduction, the right of adaptation or translation, the right of distribution, the right of rental, public display right, and public performance right, as well as communication to the public. Ang madalas siguro nyong ma-encounter dito would be reproduction right, translation right, the distribution right, rental right, hindi masyadong pronounced dito, hindi masyadong uso dito sa ating country ang rental right, but it is also a right under copyright. Public display, when you allow somebody to display your sculpture or your painting or other artistic work, uh, pwede nga literary work, a display of your book, especially if it's a rare edition, then uh, rental right is the right to have it rented, or public display is the right to have it displayed before an audience, like in a museum or in a gallery. That's public display right. And public performance right, as I said, is performing it before a public. So for example, there is a reading session of a certain poetry. I own the copyright to the particular poem. Then for you to be able to publicly perform the work, then you need my permission, you need authorization from me. Other communication to the public is anything other than public performance. So other communication to the public includes your digital media. Okay? So whenever, for example, a song or a music is performed on stage or in a television show, it's considered as communication to the public. Okay, and therefore, because it's an exclusive right, you need to request or have permission from the author or the copyright owner of the work. Then you have moral rights. Moral rights, as I said, is the connection, no, of the author to his work. So you have the right of authorship or attribution, the right to make alteration. So only the uh, copyright owner has the right to make any alteration, to object to any distortion or mutilation, and the right to object to the use of his name with respect to any work not of his own creation or in a distorted version of his name. So, dahil sikat ka na, a work which you did not do is being attributed to you as the author para mabenta siya, for example, or para tumaas ang kanyang value. You have the right to object because it's in fact not your own creation or it's a distorted version of your creation or your name, then you have the right to object to the same. Who owns the copyright to a work? General rule, copyright shall belong to the creator of the work. Who is the author of the work? The author of the work is the natural person who has created the work. So, copyright, ang first owner of copyright is the natural person who has created the work. Exceptions, there will be some exceptions in this particular case under Section 178. So, let's go through them. Pag works of joint authorship, meaning two or more yung authors, we apply the rule on co-ownership unless there is an agreement to the contrary. Meaning, dalawa yung author pero inassign ko na for example yung right, yung copyright ko doon sa one of the authors or to another party. So, unless there is an agreement to the contrary. What about if you're an employee and you created a work out of an employer-employee relationship? If it's part of your regularly assigned duties, the ownership belongs to the employer. If unless there is an agreement expressed or implied, meaning wini-waive or ina-assign ni employee yung ni employer yung or it is the policy of the employer that copyright shall still belong to the employee. Okay? And if it's not part of regularly assigned duties, then to the employee belongs to the work. It says in the IP code, even if you use company time, resources, you use the materials from the office, you use your official time to do something which is not really, to create a work which is not really part of your regularly assigned duties, okay lang yan. But you will have to be, ibang issue yung paggamit nyo officially ng official time and yung company resources to do something else. Kumbaga, you're doing something else outside of your regularly assigned duties during company time and using company resources. But the copyright there still belongs to you as the employee. I would just like to emphasize minsan sa ating mga contracts, employment contracts, merong section, there's a catch-all provision that says, and such other duties and functions that may be assigned from time to time. Such duties and functions that may be assigned from time to time means that it is not part of your regularly assigned duties. Okay, so not part of your regularly assigned duties. So if writing a speech is not your regularly assigned duty, okay, then that particular speech which you have written will now belong to you because it's not part of regularly assigned duty under this particular rule, section 178. Then commissioned works, to the commissioner belongs the work, to the creator belongs the copyright, unless there is a written stipulation to the contrary. So for commissioned works, dapat it must be part of the contract. It must be written. It must be expressly provided in a written instrument. So you commission somebody to do your painting, okay? So na-create na niya. It's a portrait of you. So the portrait as a work belongs to you, but the copyright still belongs to the creator, the one who painted the portrait, okay? Or who created the portrait. Unless there is a written stipulation, there is an agreement, in other words, between you as the commissioner and the artist as the commission per party, to na even the copyright to the work is now transferred to you. Anong implications nun? Because the creator or the artist still belong, if you want to reproduce, to make replicas of that portrait, you need to request, even if ako yung subject ng portrait or painting, yes. Because copyright, the right to reproduce it, to replicate it, is a right, it's an exclusive right of the copyright owner. Okay? Even if I'm the subject, of course, unless nga doon sa commission agreement nyo is nasa yun na rin, not just the work, but also the copyright in the work. Because of this particular principle that there is a distinction between the material object, okay, and the copyright in a work. The copyright is distinct and separate from the property in the material object subject to it. Consequently, the transfer, assignment, or licensing of the copyright shall not itself constitute a transfer of the material object, nor shall a transfer of the assignment of the sole copy or one or several copies of the work imply transfer, assignment, or licensing of the copyright. So let's take it further from that example. So yung work, yung painting nasa iyo. So yung painting, you can display it in your house, but you cannot publicly display it. Why? It's not the copyright, again, belongs to the creator. Okay, so you can display it privately in your house, in your salas, for example. But to replicate it would mean that you need to ask permission, unless nga nasa iyo na din yung copyright. So, yung artist, what can the artist do? Pwede niyang i-grant through a licensing agreement yung replication of the work. Okay? Replication of the work. Kaso, in practical terms, mahirap din mangyari yon because the physical object, for you to be able to replicate it, would mean that you need to have it before you need the specific material object. So pag ganon, then wala ka ring magagawa. But you can actually mandate that other person for you to be able to exercise your right of replication. How long does copyright protection last? The magic number is 50 years. 50 years lifetime plus 50 years. So life plus ang tawag namin dito. If it's an original literary and artistic work, it's lifetime of the author and 50 years after his death. Works of joint authorship, when you have two or more authors, lifetime of the last surviving author, and for 50 years after death. For anonymous or pseudonymous works, 50 years from date of on which the work was first lawfully published, if not published from the date of making of the work. Okay? Works of applied art, yan lang yung naiiba. Works of applied art have a protection of 25 years from the date of making. Photographic works, 50 rin from publication if published, if unpublished from the date of making. Then you have audiovisual work. Ito yung films and cinematographic works. You have 50 years also from the date of publication and if unpublished from the date of making. Yeah. Let me quickly, what happens after the period of protection? After the period of protection, the work now becomes part of the territory we call the public domain. It now becomes public domain. Pag ang work ay nasa public domain, okay, yung mga work na ito can be copied, can be used, can be utilized in any manner without the need to request permission from the author or the copyright owner of the work. So that's when it now becomes part of the public domain. Ang owner nito, in other words, ng isang public domain work will now be the public as a general collective category. So the public has access to it and can now use it in any manner. Take note, except for the right of attribution. Except for the right of attribution. The right of moral right of attribution or to be named as the creator of the work is a perpetual right. So, because it is intimately linked doon sa creator. So, kung yung nobela ni Jose Rizal, you cannot introduce it as your own work. Why? Because the right of attribution is perpetual. It will always and always, no limitang ere, will always be attributed to Jose Rizal as the particular author. What are my remedies? Paano kung kinopya? My rights have been violated. What are your remedies? Here are your remedies. You can go to court, which is the first column and the second column, or you can seek administrative remedy for copyright infringement before the Intellectual Property Office of the Philippines. So yung civil and criminal remedies are before the regular courts. Ito yung mga RTC, MTC, RTC. Okay? Ito yung regular courts. Whereas administrative remedies are before another bureau within the Intellectual Property Office called the Bureau of Legal Affairs. That's where you file the case for copyright infringement. And you also have these available remedies, cease and desist, voluntary assurance of compliance, condemnation or seizure, forfeiture of paraphernalia, cancellation or withholding of permit and license and registration, etc., including damages. Sabi natin, there is a balancing of rights principle. And now I go to fair use. No? Exclusive right, pero paano naman yung karapatan ng publiko to be able to also enjoy creative works, literary, scientific, and artistic works? That's why for certain uses, our local law, and we are unique in this, unique in the sense that there is a specific provision in our law, it's section 185 and 184 that provides for fair use. Okay. So we call it general fair use. General fair use principle is section 185.1. The fair use of a copyrighted work for criticism, comment, news reporting, teaching, including limited number of copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright. Okay? Fair use of a copyrighted work for criticism, commentary, news reporting, teaching, scholarship, and research for similar purposes is not an infringement of copyright. So what are the fair use principles under this particular section? It's PAME. Okay, that's your mnemonics for it. P refers to the purpose and character of the use, including whether such is of a commercial nature or is for non-profit educational purpose. Uh, Purpose and character of the use. So, pag pag ang purpose mo is non-profit, educational purpose, the more likely, I'm not saying ay walang automaticity dito, it's not automatic na hindi na fair use na siya pag non-profit. I'm not saying that it is automatic. I'm saying that the more likely that it will be adjudged by the court or the court will rule that it is fair use. Okay? In my position, my personal opinion is that fair use is a matter of is a judicial determination, meaning it is uh, a determination, it's a ruling that will have to be decided by the court of law. Okay? Fair use is a matter for judicial determination because then you forward certain evidences, documents to prove na uh, certain things. Okay? So, the purpose and character of the use, the more likely it will be fair use if it is for a non-profit educational purpose. The closer you get to it being a commercial, pinagkakakitaan mo, you get money out of your use, then it becomes now the more likely it will be adjudged as an infringement, hindi siya fair use. The nature of the copyrighted work, okay, if it's something that can be easily done, then the more likely that the more likely that it will be adjudged as fair use. But if it's something na mahirap gawin, okay, if it's such nature that it cannot be easily replicated, so any replication of it, any use of it other than by the copyright owner is considered, will likely be considered as infringement. So PA is amount and substantiality of the portion used. So take note, it's both a qualitative and quantitative consideration because it says here amount and substantiality. Amount means it's a quantitative consideration. Substantiality means it's a qualitative consideration. You copied only several sentences or several paragraphs, but that copying constituted a substantial portion of the work na okay because it's the gist of the work. Ito yung pinaka-importanting bahagi ng work, then it still may be considered, will be ruled upon as infringement rather uh, than fair use. So the lesser portion you use, the better, because then there is a possibility that there is a high likelihood that it will be adjudged as fair use. The effect of the use upon the potential market for or value of the copyrighted work, you made it available widely such that now it affects the market, potential market value for or value of the copyrighted work, then it will likely be adjudged as infringement. So pain is for general fair use, purpose and character of the use, amount and substantiality of the portion used, nature of the copyrighted work, and effect of the use upon the uh, upon the value for and potential market for the copyrighted work. Take note, potential market value dito it did not say it is the actual market, but if it affects the potential market for, then it will now be adjudged as copyright infringement. Then we have statutory fair use 184.1. I'll go through them quickly. We call this the private performance pag ang performance of a work is done privately, walang charge that is made, and it is made strictly for a charitable or religious institution or society. Then fair use siya, statutory fair use. Quotations, if you make quotations, as I said, di ba, parang consistent din siya actually sa general fair use. If you make just quotations, then the quotations will be considered as fair use. But it should be to the extent only justified for the purpose. Nag-quotation ka nga pero every now and then panay quotations yung kinopyan mo, so you practically covered the entire thing, then that's not fair use, that's infringement already. The reproduction or communication to the public by mass media of articles on current, ito yung news reportage, meaning for current political, social, economic, scientific, or religious topic. Then it's statutory fair use if such use is for information purposes and has not been expressly reserved. Statutory fair use din siya for reporting of current events. I'll go to letter E, the inclusion of a work in a publication, broadcast, or other communication to the public, sound recording or film, if such is inclusion is by way of illustration for teaching purposes and is compatible with fair use. Okay? So it must be such amount lang that is necessary to do the illustration for teaching purposes. If you want to illustrate something and you want to make use of a copyrighted work, okay, so that you will be able to make your point, especially ito sa mga arts classes, no? If you want to make a point and you need to make use of a copyrighted work, it must be such that it is only for the purpose necessary. It is only of the amount that is justified by the purpose and character of the use, which is illustration for teaching purposes. F, the recording made in schools, universities, or educational institutions of a work included in a broadcast for the use of such schools, universities, or educational institutions. You have ephemeral recordings by broadcast or broadcast organizations. This is applicable to broadcast. This will not be very much applicable in an educational setting unless the educational institution also has a radio network or a television network or a broadcast facility. Letter H, any use made of a work by and under the direction of the government, the National Library of the Philippines, or by any scientific, educational, or professional institution where such use is in the public interest and is compatible with fair use. Letter I, the public performance or the communication to the public of a work in a place where no admission fee is charged in respect of such public performance or communication by a club or institution for charitable or educational purposes whose aim is not private making. Okay? Public performance ito. Yung number 1 kanina is private performance. Letter I is public performance or communication to the public. However, you must meet the following requirements. No admission fee is charged. Okay? And the purpose is for charitable or educational purposes only. whose aim is not profit making. Okay, so there is a place where there is the performance of the work. Admission fee is not, no admission fee is charged. It's for purposes of charitable or educational purposes, and it is conducted by a club or institution. Then that will fall under letter I as statutory fair use. You have public display of the original or copy of a work not made by means of a film, slide, television, image, or otherwise on screen, or by means of any other device or process. So it's the actual work that is displayed. Halimbawa, uh, Arts Month, okay, in your particular institution. Then that will be considered as statutory fair use, okay? The use of a work for purposes of any judicial proceedings, anything that is uh, made available before the court, or for purposes of giving a professional advice by legal practitioner is not is fair use. And the reproduction, this is a new addition, the reproduction or distribution of published articles or materials in specialized format exclusive for the use of the blind, visually and reading impaired persons. So this is for purposes of our of the VIP sector, the visually impaired sector, and print disabled persons, for them to be able to make use of the work. There is an international treaty on this. It's called the Marrakesh Treaty. If, in case lang you wanted to find out more about it after this webinar, then it's called the Marrakesh Treaty. We are a signatory. The Philippines is a signatory to that treaty. And part of this is to be able to implement it locally is we put letter L under the law in 2013. The Marrakesh Treaty is in order to benefit the blind, visually and reading impaired persons, so that you can now reproduce a work even without permission from the copyright owner. Okay, you can reproduce the work in a format that is accessible format copy for the use of the blind, visually and reading impaired persons. Of course, ang mas familiar tayo are your braille versions, but there are other formats for purposes of our blind, visually and reading impaired persons. Let me go through the difference between infringement and plagiarism. Are they one and the same? As you may probably notice in this Venn diagram, they are not the same, but there are certain overlaps such that there may be occasions that a copyright infringement is plagiarism and a plagiarism is also copyright infringement. So here we said that not all copyright infringement is plagiarism, but and also not all plagiarism is copyright infringement. Bakit? Let's first define plagiarism. Plagiarism is the deliberate and knowing presentation of another person's original ideas or creative expressions as one's own. Sabi natin, ang original ideas, ang ideas are not protected by copyright. But, sabi ko din, pwede siyang makover ng plagiarism. If it's not your idea, but you deliberately and knowingly presented it as your idea, then that particular idea will now be protected under the regime of plagiarism. Okay? But it is not, sabi natin, ang copyright only protects creative expressions. So that's one of the areas kung saan nagkakaroon ng overlap. Because if it's a creative expression, then copying it and attributing it as your work or representing it as your work will now constitute both plagiarism and copyright infringement. Okay? So let's now differentiate between the two. Copyright infringement is the offense provided in the IP code. Plagiarism, as far as I know, is not provided in the IP code, nor in anything else, in any other law for that matter. Copyright infringement is a legal construct, meaning it's a legal concept, it's a legal thing, whereas plagiarism is an ethical construct, meaning that it's more ethical, for more ethical considerations rather than legal considerations. Kasi nga, wala siya sa batas. Because it's not in the law, then you can only rely upon copyright infringement as an offense. Pag pinag-uusapan natin ay batas whenever your right is violated. It's committed where copyright subsists, whereas plagiarism can be committed even when where no copyright subsists. Kahit wala ng copyright doon sa pinagkopyahan mo, but you represented it as your work, it may still be considered as plagiarism. It is considered as plagiarism, whereas it is no longer considered as copyright infringement. The offended party is the copyright holder. Ang uh, ang party that is offended is the copyright owner or the copyright holder. Whereas in plagiarism, because it's an ethical construct, is the community at large is the offended party. Why? You deceive them. You deceive us. You deceive the public into thinking that this particular idea or your creative expression is yours, even if it's not yours. You attributed it and represented it as yours, as your work or idea, uh, when in fact it is not. So it affects now the community at large. May panlilin lang sa publiko by misrepresenting it as yours even if it is not. Okay? So let's have a short exercise before I think I just have a few more slides after this. Mr. A photocopied an entire book. Is this copyright infringement? Is this plagiarism? Okay. This particular bullet will be considered as copyright infringement. One, there is no misrepresentation that it is his work, and therefore will not fall under plagiarism. It is copyright infringement. So the appropriate case to be filed is a case for copyright infringement, or the remedy, I should say, is a case for copyright infringement. Miss B retyped an article appearing in a provincial magazine. Akala niya siguro hindi na malalaman because she's studying, for example, in Metro Manila, placed her name as author thereof, and submitted it to a local magazine for publication in another town or city or municipality. Is this a case of copyright infringement or is this a case of plagiarism? It depends whether there is in this particular case, it's a case of both plagiarism and copyright infringement. There is a representation of the work or article appearing in the magazine as her own and submitted it to another magazine for publication. If copyright subsists in the work, then it's also copyright infringement. Mr. C reproduced an essay from a well-known essayist who died 55 years prior and represented it as his own. We know this is already part of the public domain kasi lifetime plus 50 ang ating period of protection for copyrighted works, for literary works such as an essay. So the essay has fallen into the public domain. wala na pong pwedeng maging copyright infringement yun. But there is still what you call as plagiarism. It is still plagiarism. Plagiarize pa rin siya. Miss D took the idea of her mortal enemy and made a short story out of it. This is clearly plagiarism. It cannot be protected by copyright. Ideas are not protected by copyright. Okay, I hope you are able to get the distinction. What if hindi niya ni-represent as his own, pero pinaraphrase niya? Under current rules, especially in an educational or institutional setting, yung excessive paraphrasing is also, if you do not do your paraphrasing properly, it is considered as plagiarism. And may karampatang parusa yon, especially in an educational setting such as Olivares College. Closing reminders and takeaways. Don't forget that you should know your right, and you took the first step by attending this particular webinar. So I thank particularly the organizers, Olivares College, Miss Arline, and RTL for this particular webinar so that our participants here know more about their right, their copyright, and how to protect it. You can employ technological protection measures. Technological protection measures would include putting a notice in your work. So kung photography yan, maglagay ka ng copyright notice. It's the letter C symbol and the year in which you made it. So copyright 2021, then your name if you wanted to put it. Watermark is a technological protection measure also. You can employ all of these things. Remember the copyright principles. The idea is different from the expression. The material object is different from the copyright in the work, and that there is automatic protection. Although not protected by copyright, don't just reveal your idea to anybody. You should keep track of the persons to whom you sent your ideas, especially if you're just trying to pitch in a story. Wala pa. Gusto mo lang magkaroon ng assured funder for the book that you wanted to make. You should keep track of the persons to whom you sent your ideas, and if possible, you enter into non-disclosure agreements so that that person will also not reveal to another party. Ang ending, yung idea mo, kinary out na ng iba at the end, not you. So, just to protect your idea, then you should keep track of the persons and you enter into non-disclosure agreements if possible. Kasi pag meron na siyang non-disclosure agreement, then any breach of it would be a cause of action for a case to be filed in court. Read the fine print of contracts. You should know which rights you are transferring. Pag may commission, you should know if you are the artist, what rights specifically are you transferring. Pwede bang tingi-tingi yung right na ita-transfer mo? Di ba sabi natin, yung copyright ay pito for economic rights. Can you just transfer the right of reproduction? Yes, you can. Pwedeng isa-isa yung transfer nun. You can transfer the right of reproduction to person A, the right of rental to person B, the right of public performance to letter C, to person C. So you can do that. Or you can transfer everything to just one person. Okay, so you should know what rights you are transferring. You should know its implications. And we are not just creators, but we are also users. So therefore, the reminder is to others what you would want others to do unto you. So if you want others to respect your copyright in a work or your IP rights in a work, then you should also respect the IP rights of others. In other words, if you wanted to make a work, do not copy it also from somebody else, because that would not be respectful of the rights of others, aside, of course, from the legal consequences of your action. And although there is automatic protection, we do encourage po everyone to register and deposit your work with the IPOFIL, with the Intellectual Property Office of the Philippines. It is my bureau. It is the Bureau of Copyright and Related Rights that does the registration, that accepts the registration of your work. So how do you register and deposit your work? You go first to www.ipofil.gov.ph. Under services, click on copyright. Under that particular tab, you now click on deposit copyrighted works. Why do we encourage you to register? Wala pong problema because you are automatically protected. Wala pong problema yon pag lahat ay maganda. Pero the moment na merong nangopya or that used your work without your permission, then that's where the problem comes in. If there is a problem already, sabi ko nga, ang remedy nyo is to either go before our Bureau of Legal Affairs or before the regular courts. And ano ang nangyayari? Pag nililitis na yung case nyo for copyright infringement, then you need to put forth evidences that one, you are indeed the copyright owner of the work. And that's where the benefit of copyright registration comes in. You have in your possession an official document, a document of issued by a government body stating that you are the copyright owner of such work. And it makes it easier for others who desire to use your work to identify and to locate you should they require your permission. That's why nga sabi ko, I encourage to you to put the copyright notice before your work. But at the same time, we also encourage you to make registration. Kasi kung hindi nila kayo malocate, then they can avail of our services to locate you who is the copyright owner in the work doon sa aming registry if you are registered. Hindi nila kayo makokontak kung hindi naman kayo registered, kung hindi naka-register yung work nyo before us. Okay, online filing, because it's pandemic, we have introduced an electronic filing of copyright registration. So what do you need to do? You download the form, you send the requirements and the request along with the digital copy of the work to copyright underscore registration at ipofil.gov.ph. You pay the fees online. So you will be issued an electronic certificate of electronic statement of account, and there are available payment modules already for there are payment means, electronic payment mechanisms for you to pay online. And once we receive confirmation of the payment that has been made online, we issue the electronic certificate of copyright registration within 24 working hours from completion of the document or from payment, whichever comes later. Okay, so that's how fast and that's how easy you can copyright your work. Sabi ko nga po, true, you have copyright protection in your work at the moment of creation, but there will be administrative obstacles also whenever there is infringement. That's why we encourage everyone to also register their work. Voluntary naman po ang ating registration system, and deposit your works with us. These are the existing fees for NCR registrations: 450, 625 pag big entity. Deposits in the regions are 750 for big entity, 550 Bulk deposit per certificate is 200. Wala siyang distinction whether good and bad, big, small and big entity. And of course, there is payment of a legal research fund, which is 1% of the applicable amount. I think for 450, you need to pay 10 pesos. So 460 siya. And of course, the documentary stamp tax. This is a sample certificate of copyright registration issued by the office. It states here the date of application, the name and owner of the copyright in the work being mentioned, the place of registration, the place of the owner or contact details, as the case may be. You have title, the author of the work, the type of the work, the creation date, and the period of protection. Then we attach the seal of the office, and it's signed by yours truly. You for other concerns, you may contact us at copyright@ipofil.gov.ph. For online registration, as I said, you can email it to copyright_registration@ipofil.gov.ph. You can also follow us in our official Bureau of Copyright and Related Rights Facebook page at ipofil BCRR. Okay, we have a few announcements there every now and then, yung mga webinars that can benefit you. For example, we have an upcoming August 27 webinar on contracts for application developers, mobile application developers, game developers for mobile applications. You are free to attend. Registration is free for attendance to it. You can look for it doon sa ating IPOFIL BCRR page. And to report any IP violations involving counterfeit and piracy operations at ipofil.gov.ph. Halimbawa, may alam kayo na nagbebenta ng mga peking bags, branded bags, t-shirts, then you can report them to operations at ipofil.gov.ph, and you can message them at ipofil.ieo. Doon sa aming Facebook, of course, may sarili ding messenger, yung ipofil BCRR page, and you can also get in touch with us through there. Pero wag regular working hours pa rin po, although work from home tayo, regular working hours po naman po. So it's okay naman to send your message at 12 o'clock in the evening, but do not expect us to, we are not using artificial intelligence. We are now using personal yung touch. So it's our staff in the bureau that answers your messages on the Facebook Messenger of the IPOFIL BCRR page. So expect that response will come in within 24 working hours from the time that your message is sent through the Facebook Messenger page. So with that, again, thank you to the organizers, Olivares College, Miss Arline, Regalo, RTL as a group for the promotion, and thank you to everyone for attending today's webinar. You learned a thing or two, and more importantly, we encourage you to take action on what you've learned by registering your works. We encourage you to keep on creating, especially at this time. We encourage you also to keep respecting the intellectual property rights of others. Yeah, and so we hope that this been a helpful session for all. Thank you.
Yeah, thank you so much, Attorney Kuyo, for a very wonderful presentation. So I hope we have learned something from what Attorney Kuyo discussed for today. So we will be proceeding to the next part of the program, which is the open forum. So I will be reading some questions from our chat box. Medyo madami po ito. So pasensya na po kung hindi ko po mababasa lahat. Pili lang po tayo siguro ng mga 5 questions. Okay, sige po. Let me read the first one. Um, Ayan po. E-book downloaded for free from the web and printed for personal use. Any violation for this kind? Ayan, ulitin ko po yung question, sir. E-book downloaded or for free from the web and printed for personal use. Any violation for this kind?
Okay. Let me qualify that. I think, okay. Let me just say that assuming that the the work is a legitimate or free download, meaning it's open to all, then printing it for private use, meaning for your own purpose, is will not constitute copyright infringement. It will be considered as fair use. That is assuming everything is in order. Kasi pwede na download mo siya for free, but then yung starting point mo is that it's already a violation of the copyright of another. Meaning, nagkaroon, yung kopya na yon, yung electronic copy na yon was obtained illegally, meaning by violating the copyright of another. Everything else after that, kasi if there is a violation from the source, then everything else is violation, no? You are part of the process of the infringing, but the rights of another, the copyright of another. But assuming it is indeed legitimate, free for the public, then you will now be able to, you can print it. But I think that one is also being addressed now with the new technologies. If you've gone through Kindle for Amazon, di ba, na nababasa mo na siya pero hindi mo na siya napiprint, because that's a way of the copyright owners actually to protect also their rights by saying na pwede mo siyang basahin kung gusto mo ng private use. You can use the application to read the material, but you cannot print it because that will be reproduction kasi. That's the reproduction right. You, all the more that you cannot distribute it and share it with others. So I think ganun yung aking sagot doon. I think the copyright owners are also addressing yung mga lapses or gaps sa system. So now you cannot just share it. Like I have a few copies na libre, na download ko siya on Kindle, but I can only read it using the application. I cannot even share it and email it anymore. Unlike before na madali siya eh. But now, technology is also catching up in order to protect and enforce the rights also of our artists and creators.
Okay, sir. Thank you po. For the next question, what's your take of controlled digital lending or CDL in libraries? Can this be considered fair use?
There is a, I did not mention anymore. I should have extended my discussion on fair use kasi I discussed section 185 and section 184. There is another section there that deals specifically with libraries as institutions. So I think that one will be the applicable provision for the use of materials or yung lending rights, no, under the code. I will refer to section 188 of the code. Sige, ganito na lang. If you wanted to find out more for our librarian friends, if you wanted to find out more on this, maybe you can just write us doon sa email namin for your further concerns, and then we will get back to you on this on a more detailed discussion on this. Incidentally, I don't know if we will be able to have a public consultation within this year. We are coming up with the implementing rules and regulations on the fair use, statutory fair use that I discussed earlier. Kasi may mga kailangang standards doon. Like for example, what is limited number of copies? What is uh, ephemeral, ano yung ephemeral recording. So all of this will be discussed in fair use, and when that time comes, we are ready already with the draft of the IRR, but I don't know if we will be able to do it within the year. But when that time comes, I invite everyone to please participate in the public consultation so that you can have your inputs, including yung mga hindi ko na-discuss. There is also one for computer programs na similarly fair use or exception. There is one for reprographic reproduction of libraries. There is one for works or of architecture. May mga ibang sections pa of the IP code that will be included in that particular IRR. And hello to Ma'am LV Lapus. I think I saw her here. She's a good friend and partner also of the Bureau of Copyright.
Miss Carmela, paano po ng audio?
Sorry po, ayan. Last 3 questions po. Sobrang dami po kasing nagtatanong dito. So medyo hindi ko na po mabasa yung iba. Pasensya na po. Pero sige po, last 3 questions. Meron po dito, nag-subscribe ang school para sa isang digital format database. Ang access po ay para lamang sa students at faculty. However, binigyan ng faculty o students ang access sa outside party. Ano po ang pwedeng gawin?
I think the student should be responsible for the infringement. Actually, kasi in this particular case, there is already a contract. So, ang violation doon would be for breach of that particular contract. And I think party to that breach would be the students kasi siya nga. I think wala naman, it will no longer be a question if I understand the question correctly. It is no longer a matter of whether it's copyright infringement or not, but there has been a breach kasi of the terms of the license or of the agreement. If there has been a breach and there is a dispute over it, you can go before the courts, but right now it is also covered by the jurisdiction of the Bureau of Copyright. Meron kaming limited na case handling mechanism. So if the dispute is over the terms of a license involving the author's rights to communication to the public and public performance of the work, then you can file it before us so that we can settle your dispute before us. So, but as I said, it's actually not anymore a question about copyright infringement, because in this particular case, there is authorization, which is the contract, but there has been a breach of that contract. So you can go before the courts or you can try the Bureau of Copyrights and Related Rights.
Okay, sir. Thank you po. Next po, if you have written a module as a faculty of one school, who owns the copyright? Is it the school or the faculty who wrote it?
I've been asked that very often, lalo na ngayon. During the pandemic, naging requirement for schools. So I think we go back to the basics, and the basics is provided in section 230, which says or encourages educational institutions to have their intellectual property policy. IP policy ang tawag doon, and this includes copyright. Kasi doon dapat isi-settle kung yung issues such as who will own now the module. I know your employment contracts, assuming lang let's take a scenario. If we go by your employment contracts, most likely, your employment contracts, lalo kung matagal ka na, I mean you're an old faculty in the institution, malamang wala naman dun sa detailed description mo duties and responsibilities yung paggawa ng module, because then you were doing the lectures physically, di ba? Face to face with your students. So if we go by that, then the owner of the work will definitely be the teacher. However, if there is, given the new normal, given the new situation, there has been now an IP policy, a change in the policy that provides IP policy that provides who the owners is of the work, then that should take precedence, but that should be agreed upon by the faculty themselves. I know this is a tricky and a very sensitive issue now, so I think you should start by having an understanding, common understanding between the school and the faculty as to the ownership of the modules that you do. I think sa mga centralized organizations, meaning ito yung may mga branches, there is really a unit that does the modules. So, walang problema pag ganon. But if you do it on your own, yung kanya-kanyang kayod, no, then I think that's where the problem comes in. But if we go by the traditional rule, I also understand and I sympathize with the predicament of schools. But if we go by the rules, the copyright ownership rules na diniscuss ko kanina, under an employee-employee relationship, if it's not part of your regularly assigned duties, then the copyright will belong to the creator of the work, in this case, the faculty member. Otherwise, it's a matter for the school and the faculties to agree upon.
Okay, thank you
Ako,
po,
ang
sir.
bias ko as copyright director would be to give and to grant ownership of the work to the faculty, but then, like any other property right, it can be assigned naman. It can be assigned to the school if that is the intention. But let's recognize the faculties as the creator of these works, okay? And therefore, it should be attributed, at least yung attribution should be theirs, and the economic right. But if the intention is to transfer it later on, pwede naman gawin pa rin yon. You can assign, you can license, you can transfer the copyright in a work. So let's recognize them. It's important that we recognize our faculties as well.
Thank you, sir, for answering that question. Next question po natin. Can the library put a watermark as their mark of ownership to the soft copy research materials of students submitted by their teachers to the library, and can be accessed by the next batch of students as their references, but not allowed to download the research paper?
Yes. The short answer to that is yes. You procedurally, how do you do it? I think it should be clear lang from the start, especially dun sa mga theses, no, or other materials, dissertations that are being, copies of which are submitted to the libraries. Kung ano yung rules that will govern it. But as a matter, as normally, yung mga theses are really available, di ba? Hindi yan, in fact, if I remember correctly in college, yung mga thesis work, di ba, minsan doon tayo nagre-refer sa mga nagawa ng thesis, so nagko-quote tayo minsan doon. I think that's not available to take it home So that's really the concept there. And so kung ma-apply naman, I think that principle should still be observed, but I think that whatever the arrangement is, I think it's important to be clear from the start so that unang-una kasi ang treatment of the thesis are unpublished work. So there must be all intents to protect the nature of thesis as unpublished work, whatever the form, whether it's dinigital nyo, dinilagyan nyo ng mark, etc. Still, you should honor that principle that kaya ganun yung treatment na hindi pwedeng i-take home because it is essentially an unpublished work.
Thank you, sir, for clarifying that. Sir, will you be okay to answer a few more questions?
Yeah, sure. Okay lang.
Okay po. Sige po. Next question, when will the copyright protection starts? Is it only after we register with intellectual property of the Philippines?
No. Sabi ko nga, first copyright principle that I discuss is the automatic protection. So there you have copyright protection from the moment of creation. Okay? Even naman pag ni-register nyo siya sa amin, you registered it before us, doon sa pinakita ko kanina na slide, there is a section there that says date of creation. Okay? So date of creation, pag yung mga works where the protection is from date of creation, then kung ano yung naka-indicate doon na date of creation, doon yung copyright protection. Otherwise, karamihan kasi sa protected works is lifetime plus. So, the date of creation actually does not matter. Di ba? Kasi, ang importante doon is hanggang kailan namatay yung copyright owner or yung creator. Because the term of protection is lifetime plus. But you have that copyright protection from the moment of creation. As soon as you created it, then it's now protected by copyright. Example, essay. The moment I put in my last paragraph in the essay, it's there. It's protected as a literary work. I now have copyright protection over it. And I also stated the reason bakit, di ba, kailangan i-register kahit na may automatic protection. Pag nagka-problema, okay lang kasi in good times, you don't have any problem. You can bank on the automatic protection. But in bad times, meaning may nangopya, may gumamit, ni-reproduce, dinisplay, ginaya, then that's where it's important that you have documents to prove your ownership of the copyright in the work. So that's why, that's one of the benefits of copyright registration. And in other jurisdictions, and I think it should slowly nagiging ganun na rin ang proseso dito, there are certain industries where importante yung tinatawag natin na chain of title. So, dapat napapakita kanino nag-umpisa yung copyright, sino ang unang holder ng copyright, and then tina-transfer siya, how it is transferred from one person to another until kunin na siya. What am I talking about? Example, gustong i-adapt yung film, yung isang story into a film. So for the film producer, bago pa siya mag-shoot or decide na pondohan yung paggawa ng film based on a certain story, they make sure that there will be no problem as far as copyright is concerned. So titingnan nila yung chain of title. Sometimes, how do you prove chain of title? It's also through one of the means of proving that is through the copyright registration. Kasi pag transfer, halimbawa, ni-register nyo ngayon, tapos binenta ko yung copyright ko, in other words, doon, at least the economic rights to another person. So, yung other person, pwede siyang mag-request ng recordation or transfer of the copyright. So, mag-i-issue kami ng panibagong certificate now in the name of the new owner of the copyright. So, yun. Tapos, halimbawa, itong person na to, siya ang in-approach ng producer so that they can make a film out of that story. So nagta-transfer yan. You can have this document of title as we know it, so that makampante yung magpo-provide ng financing for the production of the derivative work. Thank you.
Thank you, sir. Ayan, sobrang dami po ng question. So, konti pa, sir.
Okay,
Okay lang?
okay lang. No problem. Actually, nasa sa inyo yan. I can take as many as I can.
Okay po, sir. Sige po, let me read another question. Ayan, wait lang po. How about po downloaded from an online subscription such as online journal or magazine? Then keeping the downloaded file beyond the subscription date. Will that be a violation?
I think when you did a subscription, I will have to qualify that. Depende sa terms ng subscription nyo, no? More likely, if you are able to download a file, for example, using a subscription, then likely inaalaw nila yung pag-keep ng copy even beyond the subscription date. But I think that gap is also being addressed also by technology. Example, I'm a subscriber of Spotify. Di ba, nada-download mo naman actually yon. But once you cut off your account, your subscription, you can no longer access it. So I think technology is also coping with certain observed gaps and issues. So pag okay naman, I think there will be no problem because it's legitimately acquired. I think it will be the watch out of the copyright owner or the platform to protect themselves as well. Ibang usapan lang pag dinistribute mo. You exercise any of the copyright na. Kasi pag dinownload mo for your personal purpose, then in fact, fair use nga yun because subscription is legitimate, access is legitimate, the downloaded copy is supposedly to be legitimate, then I think okay lang yun. But to exercise any other right, aside from the one you already have downloaded, like reproducing it and distributing it to your friends, ibang usapan yon. That will already be an infringement of the copyright of another.
Thank you, sir. Siguro, sir, I'll have last three questions. Apo. Sige po. Next question, is music sampling a copyright infringement?
Music sampling, is it a copyright infringement? That one is not really settled, lalo na sa Pilipinas, because we have very few and old cases ang cases natin sa copyright. I think the issue is more pronounced doon sa mga countries or jurisdictions na mas mature ang copyright system nila, no? Like in the US, for example. And iba-iba din yung ruling. I think that's where you find the application of fair use. Yung general fair use that I lectured on, which is section 185.1 of the code. The court will decide whether fair use yung music sampling by the purpose and character of the use, the amount and substantiality of the portion used, the nature of the copyrighted work. Medyo mahirap pag musical composition, and then the effect of the use on the potential market value of the work for the court to decide on copyright infringement. I think it's a very thin line. It will depend. I think my answer to that would depend on the specifics of a case. There is no straightforward pag music sampling infringement yan, or music sampling infringement yan. In the same way that inspiration, you call it inspiration, di ba? You get inspiration from something. In the same way that an inspiration, it's also a very thin line. So I think it will have to depend on the specifics of the case.
Thank you, sir. Very informative po yun. Ngayon ko lang nalaman yung iba doon. So anyway, next question po. Last two questions. Is translation of a certain story into a local language be considered as a copyright infringement?
Yes po.
Translation.
Sabi natin, the right of translation or the right of transformation is a right, one of the 7 economic rights, di ba? Right after reproduction, you have the right of translation or adaptation or transformation. So only the owner of the copyright in the work can do that. Okay? Can has the exclusive right to allow or to make translations of the work. So, ganito ang mangyayari. You wanted to translate into a local dialect work that is written in another dialect. So, ganito ang mangyayari po yan. Even under the IP code, you need to ask permission from the copyright owner of the original work, meaning ito yung original na language or dialect where it is written, for the translation right. So you ask permission for a translation right, assuming binigyan kanya ng translation rights. So wala ka ng problema doon, di ba? You translated it now. That translated work is now your work. It's now a derivative work. You are entitled to a separate protection. So halimbawa ako, I find it very useful in my teaching yung ginawa mong book because naka-translate na siya into our local dialect, Ilocano for example. Then for me to reproduce it, I need to request permission from you. Okay? From you as the author to reproduce it, from you as the author of the uh, translated work. Okay? So, kailangan pa rin, meron pa rin permission that comes from the translator of the work. And depende po, that's why it's a very complicated, ganito na lang ang advice ko, don't be afraid to ask questions. Kasi merong mga contracts, like for example, it's true that there is permission to translate the work, pero meron siyang restrictions, halimbawa sa permission, like first 1,000 copies lang. That's what the authorization provided for. Then, anything beyond that is a violation of, not only of the contract, but will already be considered as infringement. No? So, ang mangyayari dito, if that is the case, kung may restriction, yung original permission, you need to ask permission from the author of the translated work and from the author of the original work. Na malamang, i-refer ka din ni translator of the original work. Kasi siya naman ang nakakaalam ano yung conditions or terms when he was granted the permission to translate. So kung perpetual, meaning they can produce as many copies as they want, for as long as they want, etc., then I think okay lang yon. Then in that case, you just need to ask permission from the author or creator of the translated work. I hope that's clear.
Yes, sir. I think so. Clear naman po siguro, no? Sige po. Last question na po tayo, sir, before we proceed to the next part of the program. You said, sir, that trade secrets have copyright. Manufacturing processes is a trade secret. But you said that procedure, system, and method of operation are unprotected. Can you elaborate, sir, on this?
Uh, Let me be clear with it. I did not say that trade secrets are protected by copyright. Trade secrets or undisclosed information is, in fact, uh, belongs to another category of IP rights called undisclosed information or trade secrets. Uh, at ang requirement lang doon is that the owner of the trade secret should exert efforts, okay, in order to protect such trade secret. Kasi kung baliwala lang, did not undertake any measures, then paano yon mako-consider as trade secret? Cannot be considered. You should have exerted efforts in order to protect the trade secret. So it's a different category of IP rights. I think you may have taken it from the statement that it's the mother of all rights. Yes, it's correct. So if there is a manual, a system, or a procedure that is the character of the trade secret, then if you developed a manual, you develop a manual, the manual is protected, but the specific system or procedure, if you note the unprotected subject matter, ang method of operation is not protected by copyright. In the same way, ito na lang, ganito na lang, para paano maintindihan in simpler terms. Yung mas applicable sa atin, recipe. Is the recipe protected by copyright? Recipes at present are not protected by copyright. What is protected by copyright is the specific expression of that recipe as an idea. So pag sinulat mo siya, tapos nilagyan mo ng artwork, nilagyan mo ng, dinagdagan mo pa ng explanation further, it's not just a step-by-step process, then that becomes protectable. Okay? But the recipe itself will not be protected by copyright. So ganun din siya. It's like a system of or method of cooking. So it's just the specific expression that is protected by copyright. So kung part ng trade secret nyo, part ng pag-protect nyo doon is you develop a manual for it, dapat that one should have been, you should have exerted effort to keep it to as few people as possible. Trade secret nga, no? You protected it. So in this sense, it cannot be a published work. Hindi nyo pwedeng i-publish yun because the moment you publish it, it will no longer be a secret. And therefore, may copyright siya but no longer a trade secret. Okay? So, no, I did not say that copyright protects trade secret. Copyright protects the creative expression related to a trade secret. Whatever, if it's a drawing or if it's an illustration, di ba, kung ang secret nyo ay ganon, then I think that's where it comes in. Yes.
Okay, thank you so much, sir, for answering the questions wholeheartedly. Sobrang na-appreciate po namin. Thank you very much. Sir, marami rin po kasi ang nag-a-ask if we could share your PowerPoint presentation and the recorded ano po, copy of this program.
Yes,
If you
okay.
allow us. Oh, yan.
Yes.
So, lahat po ng nagtatanong na kung pwede pong i-share namin yan, isasend na lang po ng aming organizer, yun pong copy. Sir,
But
thank
I
you so
think
much.
I made a condition lang if
Yes, po.
my presentation can be shared. I don't know what I sent. If my presentation can be shared via a PDF format
Yes,
rather
sir.
than the PowerPoint.
Yes, sir. Sige po. Ayan. Thank you so much. So, we'll proceed to the next part of the program. Ayan, maraming salamat po sir for asking the questions wholeheartedly and for the very informative presentation. Okay po, we will present the Certificate of Appreciation to our resource speaker. Let me read the citation. Olivares College Tagaytay presents the Certificate of Appreciation to Attorney Emerson G. Cuyo for sharing his valuable knowledge as a guest speaker at the webinar entitled Advancing Knowledge in Copyright, Fair Use and Intellectual Property with the theme Excellence Amidst Quarantine, Retooling and Recalibrating. Given this 20th day of August 2021 via web in Tagaytay City, Cavite, Philippines. Signed, Ms. Arline M. De La Cruz, Chair for the webinar, Dr. Jean Riza A. De La Cruz, RN, College Dean, Ms. Evangeline L. Olivares, MBA, VP for Finance and Administration, and Dr. Eric L. Olivares, VP for Academics and Services. Thank you so much, Attorney, for being with us today po. Maraming salamat po. We really appreciate it. And for those who have joined us for today's webinar, maraming salamat po sa ating 646 subscribers. Subscribers, yan. Parang ano, parang vlog, ayan, sir. Parang nag-talk show tayo dito ng bahagya. Thank you so much for also giving me this opportunity to host this event. It's really an honor. Maraming salamat po. Okay, so we'll proceed to the last part of the program, which is the closing program. Ayan, may I invite our library director, Dr. Melquiades Alipoon.
I'm going
and your families your personal best for your health and safety.
Hi, Sir Mel. I think nag-vlog po kayo.
Sir Mel?
Time out of your busy schedule.
Naglalag po yata si Sir Mel.
My genuine thanks are of
Yes, Sir Mel. Nag-vlog po kayo.
like to close my remarks and officially announce the end of this forum. Soon. God bless and keep safe everyone.
Ayan. Thank you, Sir Mel. Ayan, medyo nag-lag lang po yung inyong presentation, closing remarks po. Pero anyway, thank you so much for the closing remarks. So, doon po sa mga nagtatanong ng evaluation, ayan, ito po yung aming link, evaluation link, and yung aming QR code. Kindly scan the code lang po and the evaluation link. Ayan, so you can do the evaluation for this event. Yeah, okay, with that, thank you so much for being with us today. Yung ating pong webinar entitled Advancing Knowledge and Copyright, Fair Use and Intellectual Property. Thank you once again to our guest speaker, Attorney Emerson Puyo. Maraming salamat po for being with us today. And also to the organizers of this event. Of course, initiated by Olivares College Tagaytay Learning Resource Center and partnership with Regalo Touching Lives. Maraming salamat po. Have a great day, everyone.
Thank you. Thank you very much. Konting announcement lang po sa mga ating participants. If you want to uh, receive the PowerPoint presentation at the same time the recording of this webinar po, kindly answer the evaluation form. Maraming salamat po. Again po, if you want to receive the slide of Attorney Cuyo, at the same time the link po ng recording na ito, please answer po the evaluation. Maraming salamat.